Hello, everyone. Welcome to McGill Cares, a weekly webcast series addressing a wide variety of topics to support family and informal caregivers. I'm Claire Webster, a former caregiver who became a certified Alzheimer care consultant and founder of the McGill University Dementia Education Program. I work with a dynamic team of leading healthcare professionals to oversee this program, which include Dr. José Mtre from the Division of Geriatric Medicine, Dr. Serge Gauthier, McGill University Research Center for Studies in Aging, and Dr. Gerald Freed, McGill Steinberg Center for Simulation and Interactive Learning. These webcasts are made possible thanks to the generosity of our donors, and today's webcast is made possible thanks to the Henry and Berenice Kaufman Foundation. So today we will be discussing planning for the future and protecting a loved one's finances. I would like to introduce my guests, who are both graduates of McGill University. Rhonda Rudick is a partner at Davies Ward Phillips Vineberg. Her practice includes a strong emphasis on estate planning. Janet Michelin is a partner at IMK who regularly represents and advises mandataries, estate liquidators, and trustees on their legal obligations. She is currently co-lecturer at McGill University, where she teaches trial advocacy. Both graduated from the McGill Faculty of Law in 1996. Thank you for joining me today. I'm very, very happy to have this webcast because I've had a lot of requests to discuss this topic, which can definitely be overwhelming for many family members, especially those navigating dementia with a family member. Rhonda, though, before I even begin getting into the questions about specifically to do with dementia, why is it so important for family members to have a will?
Well, thank you, Claire. I mean, the reason it's so important to have a will and to have conversations with family members before something like dementia sets in is that the family, whether it's the couple or the family as a whole, has to turn their mind to, what if something happens to me? You know, what happens next? Who will handle my affairs? Who will handle my healthcare decisions? Who will handle my financial decisions? People often try to stay away from these what ifs. They're not comfortable, but you have to take the time to plan for the future before something like this happens, like dementia, because if you haven't planned, it gets very complicated. So the key is really to get your affairs in order before you have a diagnosis of dementia.
So if we get right into it with regards to dementia, so what are the first steps that need to be taken to organize financially after diagnosis of dementia?
So once there's a diagnosis of dementia, the steps to take really depend on whether the individual is still considered mentally capable or not. So if they are still mentally capable, which is often the case at the beginning of a diagnosis, if they haven't already done so, they should take steps to ensure they have the necessary legal documents prepared so that their property and health decisions can be made by the persons they choose and in the manner they choose. They might want to put one person in charge of their health decisions, another in charge of their finances. They may want to arrange for a loved one to have signing authority over their accounts. They also should prepare a list of their assets, their bank accounts, their brokerage accounts, safety deposit boxes, insurance policies, passwords, just get everything organized. If they have any assets outside Canada, they might need to seek legal advice in that jurisdiction. They should advise their loved ones about bills that need to be paid and when. Just really get everything organized.
So what are the legal documents needed in order to ensure that your loved one's interests are protected?
So the main legal documents are a power of attorney, protection mandate, an advance directive, and a will.
Okay, and so the big question that I get all the time is, what's the difference between a protection mandate and a power of attorney, a will, and an advance directive? So these are the documents that if you can please go through all of them, because it's so confusing for people.
Okay, so while a person is capable, a power of attorney can be given to another person to manage their financial affairs. For example, banking, bill paying, investment decisions. And it can be withdrawn at any time while the person's capable. But one thing that people don't often realize is once the loved one becomes incapable, the power of attorney is no longer valid. So it's just, I'm capable, but you give authority to someone else to take care of certain matters. Once you are incapable, a protection mandate allows the persons named in that document to make your health and property decisions, but it has to first be homologated by a court. So there's an interim period where both your power of attorney and your protection mandate are technically not valid. It's a bit of a gray zone. There's no real perfect answer, but people usually tend to continue acting because, you know, bills need to get paid and things need to get done. Basically, you can have a separate mandate for health and for property, and often that's the case because you might want your loved ones to make your health decisions, and if your estate is complicated or, you know, you have a large amount of assets, you might name a combination of people to manage your assets, and maybe your lawyer, accountant, financial planner together with a loved one. And you might not, you know, want your bank to see your health decisions in the same document. So often they're separate, but it's really, if you're incapable, who takes over. And an advance directive contains specific instructions about what to do in certain health situations. So they can provide what kind of treatments might be given and at what point they do not want to receive life-sustaining intervention. They can have specific dementia directives. So saying at this stage, I want this care, and at this stage, I want or I don't want that care. And finally, a will basically sets out your wishes when you die. So how is your property distributed? Who are your executors and their replacements? It can, you know, it'll contain specific gifts, or how is the residue divided? It can contain trusts. The problem is if there's no will, then the civil code determines who gets your assets. So it's really, really important to have a will.
So how do we obtain all these documents? So can you take me from, you know, okay, let's say the basic will, is it done through a notary? Is it done through a lawyer? And then all the other advanced directives, does a doctor need to be involved? Does a social worker need to be, like, for those people listening who haven't even gotten to step one, how do we go about it?
Okay, so let's start with the will. There's three types of wills. There's a holograph will, which is basically a handwritten will where you write down your wishes. This is usually like a 1 or 2 pager when everything's really, really simple. There's a will before witnesses, which does not have to be handwritten. And that needs 2 witnesses, and you need to register it with the bar. And then there's a notarial will, which is signed before a notary in front of a witness. And I really would encourage people and strongly recommend notarial wills. We don't have probate fees in Quebec like other provinces, but a non-notarial will does have to be probated in Quebec. So it's an administrative procedure before the court, but there is a cost involved, there are delays involved, and during that period, your estate is essentially frozen. So the assets aren't available to pay your bills, you can't sell property. So if you have a notarial will, it makes proof of itself and you can avoid probate. And in terms of who can draft it, a notary, if we're talking about a notarial will, a notary can draft it, but often if it's a complicated estate, a tax lawyer or estate planning lawyer will draft the will and then send it to the notary for execution. So these are usually in cases where you have a large estate, or it's complicated, or it's a second marriage and you have a spousal trust, or you have cross-border issues. You might want a spousal trust to protect the assets so that they're preserved, or if there's like a family business that you want to continue for your family, you're going to have a little bit more of a complicated will, and often then the lawyer will draft it, and then the notary, you know, actually witnesses or executes the will. And during COVID, the government has actually allowed for online execution of notarial wills, so it's very convenient because people don't want to go out in certain cases. So it's a way, as long as you have a computer with a microphone and a camera and you have a cell phone, then you can actually execute your documents before a notary online. And a will, what's very important about a will is you really have to, you have to go back to it every 5 or 10 years, as long as you're still capable, because things change, your situation changes. And if it's small tweaks to your will, you can do a simple codicil, which again, if it's a notarial will, it can be done before a notary. And if if there's major changes, you re-execute your will, but it's important to revisit it. For protection mandates, these again can be signed before witnesses and be registered, or be done before a notary. Advanced directives can be signed before witnesses, and there's actually a form on the RAMQ website for advanced directives, which people can find, or again, it can be done before a notary. And powers of attorney can take many forms. So what's often a good thing to do is to show the draft to your financial institution and see if it's okay with them. Some of them want a notarial, some of them, one paragraph work. So it really depends.
So what does a protection mandate allow the mandatory to do? Like, what are the limits of this document?
So the mandatory essentially steps into the shoes of the incapable person and makes decisions on their behalf regarding their health and property, subject to any instructions in the document. So if, for example, you're taking care of your children and providing them X dollars a month, you're going to want to put that in your mandate that the mandatory should continue doing that. There's are certain limits, though, on the mandatory. They're set out in the civil code, so they have to preserve the property and in certain cases make it productive. They can sell the property where the circumstances warrant, but they can't make gifts of the property unless the mandate specifically authorizes them to do so. There's all sorts of rules. They can't exercise their mandate in their own interest or enter into any contracts on their own behalf with respect to the property in the mandate. They can't have a conflict of interest. They can't mingle the property with their own. And they can delegate limited aspects of the mandate, but they can't simply delegate the whole administration to a third party.
Okay. Thank you for all of that. So Janet, what is the process for having a protection mandate homologated, and how long does this take?
Thank you, Claire. First of all, I just want to say thank you for having me. Thank you for inviting me to participate, because I do think these are really important issues that people don't know enough about. No. So in terms of the process for homologation, the step one is to confirm whether the person in question is actually incapable. So what the government process requires is obtaining a medical and a psychosocial report to confirm that the person actually lacks capacity. There are actually government forms that are used. You can find them on the Public Curator's website. And most professionals who work in this area know about those forms and know where to find them. So the medical form is typically prepared by the person's GP, if that GP has had a long relationship with them. The medical report can also be done by a geriatric specialist, a psychiatrist, and sometimes a neurologist, especially if it's a particularly complicated situation. The psychosocial report is prepared by a social worker. In my experience, certainly social workers in the public system do them and are available. So if the person is known by the CLSC in their area, you can ask the social worker who works there to do it. Oftentimes people will resort to private social workers because there just tends to be able to do it more quickly. And the cost is not exorbitant. Once you have those two reports, and sorry, just to clarify, the social worker will not only meet the person in question, but will also typically talk to or interview members of the family, especially the members of the family involved in the person's care, and definitely the people who are named in the mandate to be responsible for their affairs. Once the medical and social, edit that again. Once the medical and psychosocial reports are obtained, the next step is to do what's called a mandate search. So as Rhonda was mentioning, lawyers and notaries prepare mandates and they have to register them. Lawyers register them with the Bar of Quebec. Notaries register them with the Chamber of Notaries. So it's necessary to do a search to see what is the last mandate, or even if the person has a mandate, because sometimes you don't know, to see what's the most recently dated mandate. So to do that search, you actually need those reports. And again, there's a form to complete. You can find them on the Bar Association's website and on the Chamber of Notaries website. And the form is typically completed by the professional that you've mandated to homologate the mandate. Once you do those searches and you get the results back confirming that you have, that there is a mandate, you can then start drafting the application to homologate the protection mandate. So the applicant is typically the person or people named in the mandate. So as Rhonda said, sometimes you can have a person for the person's health and then someone else for the assets, and usually both of those people or entities should be the applicants. The respondent is the incapable person, sometimes referred to as the concerned person. It's really important that they be notified with these proceedings. And then the procedural rules require that this application also be notified to two other, typically family members, but sometimes you have people who don't have a lot of family members, in which case it could be two close friends. And then finally, the applications must be notified to the Public Curator of Quebec's office. This isn't to say that the Public Curator will get involved, but they keep a record of all of these applications, and so they have to be notified of it as well. So once the application is prepared, and you would go see a lawyer or a notary to prepare the application. So typically the people who come see me are the mandataries. They already have a copy of the mandate, and they say, okay, my loved one is becoming, more and more incapable. So they will come see the lawyer or the notary to prepare the application. Once the application is prepared, it has to be, as I said, notified, which can mean different things. Sometimes it's by email, sometimes it's by bailiff, to the people that I've mentioned, and it can be presented at court. It's a minimum of 10 days after the date of notification. Most cases are not contested, meaning nobody is objecting to the homologation, in which case on the date of presentation, the court clerk, they're called clerks, but they're actually lawyers by training, will take the file and then they refer it for judgment. And in that process, there's another step, which is that somebody, the court clerk who's responsible for the file, will actually also go and meet the concerned person, the incapable person. This is intended as another protection because, of course, these proceedings are going to be taking away the civil rights of this concerned person. So there's a lot of protections in place to ensure that there's no abuses. So the court clerk will usually contact the lawyer or the notary and say, I want to come do a visit. Right now, in COVID, the visits are being done by video. And this basically is a short questioning of the incapable person. It's usually 10 or 15 minutes just to confirm the incapacity and to make sure that they're aware of, if in most cases, of the person who they've asked to take care of their affairs. Of course, there are some cases where the person is so incapable that can't be done, and there is an exception in place in those cases. But I would say, in my experience, most of the time, the clerk will make that appointment. And then once that interview has been done, I would say it's another, 6 weeks or so to get a judgment. So in terms of timing, from the day you serve the application, I would say you're looking at about 2 to 3 months to obtain the judgment. And of course, there's some time that's involved before you prepare the application to get those reports. So people shouldn't think that this is like a really quick process. It does take a few months. However, of course, there are sometimes urgent situations where there's sometimes health issues, but more often transactions involving assets that might have to be done on an urgent basis. And in that case, there is a possibility of applying to the court for what's called Provisional Administration. And that's where you would basically tell the court, this person is incapable. I'm starting the process to homologate the mandate. And in the meantime, I would like you to name me Provisional Administrator of their assets so that I can do very basic things like pay their bills and maintain the status quo. Provisional Administration would not allow anybody to do anything out of the ordinary course or out of the ordinary, like selling assets, selling houses, anything like that. It's really just to maintain the status quo.
Mm-hmm. It's so the process in general, let's say from the very beginning until obtaining, so we're looking at a year, 18 months?
No, I would, no. It's less than a year. I would say it's probably from step A to step Z, probably about 4 months. Okay. But I would say that in my experience, the applicant, the person who's quarterbacking all of this, does have to be pretty proactive because doctors and social workers are busy. And, especially with the social worker report, which is a more comprehensive report, there's lots of interviews to do and it's a bit longer. You need to, stay on top of it to make sure it stays moving.
Okay, so I'm going to ask you a question that I see a lot. What happens if the dementia is progressed to the extent such that my loved one is not of sound mind and they have no protection mandate or have not given power of attorney to anyone?
So in those cases, then what you do is you can make a request to the court to open what's called a protection regime. And the protection regimes right now in the Civil Code, there's something called tutorship, which is usually for people who are either temporarily or more commonly partially incapable. And then there's something called curatorship, which is for somebody who is totally and permanently incapable, which is probably the example that you're giving. What you should know is that there's actually a reform in place right now, and the law is probably going to be changed in the next year or so, because I think the steps have already been taken to eliminate curatorship and to just have tutorship, with the idea being that it will allow courts and decision makers to be a bit more flexible about, if they're totally incapable, it'll still be a tutorship, but more powers will be given to the person who is the tutor. And if there is some residual capacity, then it allows for flexibility to, ideally allow the incapable person to still keep some, residual decision-making power. So in terms of the situation where there's no mandate, the process is actually somewhat similar to homologation of a mandate. So step one would be obtaining the reports that we talked about earlier. Step two would be doing a mandate search in order to confirm that, in fact, there is no mandate. Step three would be an application to the court. In this case, instead of a mandatory, it's the person who is proposing that they be tutor, again, to the person or property. Only an individual can be tutor to the person, not any kind of trust company. If, for whatever reason, the family thinks that it should be two separate people, then ideally both the tutor to the person and property would be the applicants. Again, similar to homologation, it's notified to the incapable person as well as family members and the public curator. So up to that point, it's a very similar process. Where the process then differs is that a meeting has to be called among family members. So in the application, you will actually include a list of as many family members as possible, because at the meeting there has to be a minimum of 5. And you will say, these are the people we want to call to the meeting of friends and family. Again, for people who don't have a large family, you can include close friends. And also, again, this is more recent, a lot of family members don't live in town. And in the last couple of years, they've now been able to do meetings with video conference. So that's actually helped a lot. So you have a list of at least 5 people who can be called to that meeting. And then you file your application where you would be requesting to have the meeting and ultimately to open a tutorship or curatorship. Once that application is filed with the clerk, again, assuming it's not contested, the clerk will contact the lawyer or the notary and will say, okay, here are some dates for the family meeting. And there's a special notice that you prepare to send it out to these various people to ask them to come to the meeting. In non-COVID times, the meeting is held at court in a room with the court clerk, not like in a courtroom. It's more just like a conference room. And if it's video conference set up for members out of town, they do that. And at that meeting, and usually the incapable person is not there, although I have had meetings where they are there if they're, on the more capable side, if they still have some decision-making power. And at that meeting where at least 5 people have to show up, the people will just confirm that they're in agreement with the application, that they agree that the person proposing to be the tutor is an appropriate person. And the other thing that happens at that meeting is that they appoint the members of the tutorship council. So this is a council made up of 3 people, usually from among the people at the meeting, and they are basically serving a supervisory role to the tutor or curator. So basically, if certain decisions in the Civil Code the tutor can make, certain decisions they have to get the opinion of the tutorship council, and then even other decisions they have to go get court permission. They have less power than a mandatory in a mandate. They can do less with the assets. Usually, it's the main differences are in the powers they have over the assets. So once the family meeting occurs and everybody agrees on what's going to take place, then within about a month, the clerk will issue a judgment where they will declare the incapacity. They will appoint the tutor to the person and property. They will name the members of the tutorship council, and they will send out the judgment. The timing of that is similar to the homologation of the mandate, perhaps a touch longer because there's extra steps. So I would say from start to finish, maybe about 6 months. And finally, unlike in a mandate, the public curator has a little bit more of a role. They have a supervisory role, and the tutors to the person and property have to render account and report annually to the public curator. There are forms on the website that the tutors have to complete. And they also have to report annually to the members of the Tutorship Council.
So, oh my gosh. So what is the website so that we tell everybody where could they get this information?
I don't know it off the top of my head, although if you Google Public Curator of Quebec, you will find it. And there's actually a tremendous amount of information on that website. It really is quite useful.
Okay. So the next important question is, what happens if a person with dementia starts making financial errors, which, you know, oftentimes a couple of years before the person's actually diagnosed, we've noticed unusual business transactions being taken advantage of financially by, you know, fraudulent business people, or just, you know, making errors of solicitation emails. Does the family have any recourse?
Well, in my experience, when that starts to happen, that's usually when the family members start the process of either homologation or opening a protective regime, because they realize that their loved one is seemingly less able to manage their own affairs. So I would say that's often the incident or episode or episodes that start the process that we've just been discussing. And then, as I mentioned, in an urgent situation, like let's just say the person has started to give, you know, cash gifts to their friends, or has started, you know, agreeing to every solicitation call they get, then you can actually run and you can do this application for provisional administration. And I didn't mention it earlier, but when you present this application for provisional administration, you have to outline all the reasons you need to get some kind of control on an urgent basis. But if it's not contested, you can actually obtain a judgment for that, I would say like within a week, even less in some circumstances. When you have to do something urgent at court, you can get a judgment pretty quickly. So that's what I recommend when people start to see that their loved ones are starting to make poor decisions.
So, but what happens if the family member has given away substantial amounts of money? Like I had a case where a gentleman had given a substantial amount of money to a charity, and you know, the daughter tried to intervene and realized, you know, my father had already given this charity money 6 months prior, and he's made another donation, which he should not have done. Can the family go back and like say to the charity, I want my money, he accidentally gave this money? Like what happens in cases like that?
So in cases like that, I mean, there's no sort of perfect answer. Basically, the donation that the incapable person would have made, it's basically like a contract they've entered into. A donation, a gift is a kind of contract. And the basis for annulling a contract is to say the person, one of the parties, didn't understand what they were doing. So if you have a situation where, for example, the charity just says, no, sorry, I got the money, I'm not giving it back. In a case like that, the only recourse the family would have is once they have obtained, once they've been appointed as mandatory or the tutor and they can now exercise the legal rights of the incapable person, they would actually have to institute a lawsuit against the charity in the example you gave, or against anybody else who was taking advantage of the person. Now, in the charity's case, I don't think it would be a situation necessarily of exploitation as much as just, you know, the person didn't understand what they were doing. And there, the family would have to make proof that the person who made the donation really was incapable, that they didn't understand what they were doing. And in cases like that, similar to when you annul wills, it requires expert evidence from physicians, from people who examine the person to say they didn't understand what they were doing.
So like same thing with business transactions, right? If somebody is investing in business or investing in, I don't know, stocks or, you know, and just did it without thinking logically or something that they wouldn't have done before.
That's correct. In the situation you gave, as I said, it's I wouldn't characterize it necessarily as a situation of exploitation, which is why I would say it's almost a pure contractual case where you're saying, you know, the person didn't understand what they were doing. And I've had files like that, for example, where, you know, we once had a file in our office where the person was approached, they had a very nice house, and was approached by a real estate agent saying, I could get you a great price on your house. So the person signed a mandate and the real estate agent, you know, found a buyer, and that person agreed to sell their house when they really didn't understand what they were doing. And, you know, we had to take proceedings to get those contracts annulled. You know, there's other cases where you might sort of find more pure cases of exploitation. where the recourses might be the same, and that if the person will not give the money back, you actually have to sue them to get the money back. In that case, it's not so much a contractual argument, although of course you're trying to say it's similar, but there's more a component of exploitation. And in Quebec, aside from just the civil code, the Quebec Charter of Human Rights and Freedoms contains a protection in section 48 in which it states that it is, obviously against the law, and people cannot exploit vulnerable and elderly people. So even though there's actually not a ton of jurisprudence on section 48 yet, it's actually being invoked more and more. And so as where you wouldn't necessarily invoke that kind of claim against a charity, we certainly see cases, as you've mentioned, where, supposedly close friends and family are suddenly getting checks and cash from the elderly person, and that's where it would be the same situation. You would have to sue them to get it back, to say that they took advantage of a vulnerable person in a vulnerable situation, and you would sue to get the money back.
So on the same topic, what types of fraud can occur to older people whose cognitive abilities are declining? I mean, I've seen, various situations of, like you said, giving away money to individuals, just being, or believing certain email solicitations. What have you seen in your practice?
So what I've seen is actually it's less email solicitations, although I've heard that it's generally much more exploitation by people who are close to them, sometimes caregivers, sometimes family members, and sometimes just, so-called friends who ingratiate themselves into the person's life. So I can give you a couple of examples. Like I have an example right now, for example, where the mother of my client was, if not totally incapable, certainly was vulnerable. And actually part of her incapacity, which is sometimes the case, is to have sort of hostile feelings towards family members. Mm-hmm. You can sometimes see that. And it's not necessarily that the family member did anything wrong, but that the incapable person sees that. And somebody else befriended her and ended up convincing her to name that new friend as a mandatory. So that person became the mandatory. And the mother eventually did become totally incapable. And to make a long story short, in the various legal proceedings that have followed, we have learned that the mother, years before she actually became incapable, but when she was certainly vulnerable, gave this new friend like $1 million to buy a house.
Oh my gosh.
This is actually probably the most extreme that I've seen. Mm-hmm. And that friend is going to claim, because it's not litigated yet, but that friend will say, well, she knew what she was doing and she wanted to give me a gift. It's a very wealthy family, so It's not to say that she had no money left, but it's the most egregious case I've ever seen. And we are going to have to prove that if and when we litigate this, that the friend was taking advantage of a vulnerable person, was sort of probably denigrating the family to her, because that's another common thing we see, where somebody tries to isolate somebody and say, nobody loves you but me, nobody cares about you but me. And in order to build this relationship of confidence, and we will try and prove that, but it is in court, it is a very difficult burden, unfortunately. And this person will say, well, no, the lady wanted to give me a gift. It's probably an easier case to prove in the scenario I just gave you. Other typical cases are, between, say, the siblings of the incapable person, where the mother or father has been giving gifts to one sibling, and the other sibling says, you've been taking advantage, you've been bad-mouthing me. And you really see it a lot when there's a sibling in Montreal or with the person, and other siblings are out of town. Mm-hmm. So there's this tension that develops between the sibling that sees themselves as the primary caregiver and may or may not be taking advantage. They aren't always. And then other siblings come to town and say, well, I want to see all the books and I want to see all the accounts. And I have seen files where the sibling in town has actually isolated the mother or father and has taken advantage. So those are the kinds of things that I see. And then once you start the homologation process, and these are what I refer to as, like, these are contested files, not like what I was speaking about earlier, where there's real litigation, and you start doing depositions and you ask for bank statements and investment account statements and credit card statements. And you basically almost have to do a forensic accounting. And then if you see that the expenses just make no sense, I've had files where I had credit cards where the person was going to Harry Rosen. Well, it was his mother's credit card. She wasn't buying clothes for herself at Harry Rosen, for example. And then you basically have to litigate to get the money back.
So what can be done to best protect the person then who has the cognitive decline from all of this?
It's really, I find this one of the most challenging situations because unfortunately I would say there's not a lot of protections in place before the person is incapable. Once they're incapable, there absolutely are, but it's that gray area where the person clearly has some cognitive deficits, but you wouldn't be able to say they don't understand what they're doing. So in families that don't have tensions already, and even families that do, I actually think transparency is the best thing. Rhonda was talking about planning all of this out. I think that ideally you want to plan this all out with the members of your family around the table. Have the parent, if they can, when they're planning, explain to one kid why they're picking the other kid to be their mandatory. The other thing that I think actually is really important, though, when you're doing that planning is there's something called the rendering of account. So this is an obligation in the Civil Code, and it basically means that the person who's administering property, either under a power of attorney or a protection mandate, has to render account to other people as to how they have been managing the money. And certainly there's this instinct where people say, well, I don't want people to have to answer to anybody else. I want them to be able to do what they need to do. But I happen to believe in transparency. I actually do think it's the best way to avoid fraud and exploitation. So I think that when people are making their plans, they should put in their mandates and tell their lawyers and their notaries to put it in, that the person administering their assets has to render account to perhaps one other family member, maybe even to a lawyer or to the notary, to somebody, so that there is some oversight. In tutorships, as I mentioned earlier, the public curator will have some oversight, at least on an annual basis. But in a mandate, sometimes there's no oversight. So I think there should be some, so that another member of the family or maybe some other objective third party will be able to see what the administrator is doing. The other possibility when it comes to exploitation on the financial side is if it's a person with significant assets, they can name somebody objective, like a trust company or an accountant, to administer their property, or they can name co-administrators, the trust company or the accountant with a family member. That would also be another way to protect against exploitation.
This is a true example, an important lesson today's webcast on how important it is to really plan ahead. Like prior to anything happening to anybody, I guess the younger you are, the better it is to have a will, make everything clear, be transparent among family members, like really have a plan in place. Because if not, it could truly become a big mess, right?
Yes, I would say that it's much easier to avoid the kinds of problems you're mentioning if the planning is done right, rather than when it's already presented as a fait accompli and you have to try and undo things using the justice system, which especially for cases like this involving family members and probably long simmering tensions, the court and the judge is a very blunt instrument to handle these kinds of situations. So it's better to plan ahead.
Yeah. Ladies, thank you so much for joining me today on our webcast, which I know is going to get lots of viewers because of such an important topic. And I will make sure to put some important resources on the McGill Dementia Education website under the resources section that people can go to. But thank you so much for being with me today. A real pleasure.
Thank you for having us.
So everyone, please join us on Wednesday, September 30th. Our next webcast, and the topic will be the correlation between cardiovascular disease, stress, and dementia. And my guest will be Dr. Nadia Giannetti, Associate Professor in Experimental Medicine at McGill University and Chief of Cardiology and Medical Director of the Heart Failure and Heart Transplant Center at the MUHC. And I will also be sharing my personal journey with cardiac issues and the impact that it had on me. A reminder that this webcast is an initiative of the McGill Dementia Education Program, which is funded by private donations. Once again, I would like to thank the Henry and Berenice Kaufman Foundation for sponsoring today's webcast. If you would like to make a contribution to our program or for more information, please visit www.mcgill.ca/dementia. And if you have specific topics or questions that you would like to address during our weekly webcast, please email us at dementia@mcgill.ca. So until next week, take good care of yourselves and your loved ones, and thank you for watching.